स्टार्ट करें अशोक जी। अशोक जी। हाँ ठीक है। Good evening, everyone. Welcome to the session on the CA indirect tax laws. And the topic what we are going to cover today is the topic on advance rulings. If the last session we discussed the topics on appeals and revisions. Uh, in that we had seen the various appellate remedies which the taxpayer had on for whenever he feels that the order of the GST officer is not correct, what he can do. We saw the fact of the appellate authority, and also in case the appellate authority also does not pass the order, which is to the satisfaction of the taxpayer, then he can also go to the uh, GST appellate tribunal. We saw the way in which the GST appellate tribunal functions, and then post that we also saw the cases where the High Court is involved, and apart from that also the cases where the Supreme Court is involved. So elaborate discussion on appeals and revisions was done in the previous session. So now we are going to take up the topic for advance rulings. Now when I say advance ruling, what does this mean? Now many situations when the law is being interpreted by the taxpayer, he may always have a doubt as to whether what he is interpreting, whether it is correct or not. In case he has the doubt, rather than taking a stand which he feels is correct, and then later getting a notice from the GST department, and then later going out on appeals to the appellate authority as well as the GST appellate tribunal, what the government felt is, why don't we have an authority which gives advance ruling? Now, when I say advance ruling, it means whenever the taxpayer has a query on certain specified issues, he can apply for the opinion which is to be given by the authority for advance rulings. The application is to be filed by the taxpayer, and the authority for advance ruling will examine the application, will examine the issue which has come forth for the clarification, and accordingly the authority will pass an order stating their view, right? This will enable the taxpayer to proceed without the fear of litigation, to proceed without the fear of making a wrong interpretation, because the GST department's decision is there in his hands. So this will enable him to be more confident, and therefore because of this he will not have to worry on any adverse interpretations which may be taken by the GST department at a later point of view. So therefore, in a simple terms, an advance ruling is a decision which is given based on the application of the taxpayer regarding specified issues. Now, please remember, advance ruling cannot be taken for everything. It has to be taken only for certain specified issues. What are those issues? Those are clearly mentioned in the section. Only if it pertains to those particular issues, they can make an application to the authority for advance ruling. Advance ruling also is there in income tax to some extent. Okay, but however, in income tax, there are a lot of judicial precedents which are there, due to which the clarity of the interpretation is much more as compared to the GST. But when it comes to GST, there is not many judicial precedents because the law is just 6 years old. So therefore, because of this, the confusion of interpreting the provision is much more as it comes as compared to the income tax. So that in brief was the concept of advance rulings, what we are going to discuss in today's chapter. Good evening, Viraj. Good evening, Shailesh. Nice to see you here. And I hope you are revising all the topics what we have discussed in the previous sessions. And I hope you are getting clarity on what we have discussed without any gaps in understanding. Now, so therefore, what exactly an advance ruling does? An advance ruling basically helps the applicant in planning his activities which are liable for GST payment well in advance. So therefore, the most important point, please make a note of it, it helps the applicant to plan his activities. Whenever there is a GST liability based on certain activity, an advance ruling helps him to plan better. It also brings the certainty in determination of tax, as the ruling given by the authority for advance ruling is binding on the applicant as well as the concerned officer or the jurisdictional officer. That means what? Now, whenever I have any query, let us take an example here. I am not sure what is the GST rate on steel. Okay, there is a confusion in the rates with regard to steel. So I have a doubt as to what is the rate, whether it is 18% or 12%. So therefore, I make an application to the advance ruling, authority for advance ruling, that is what it is called, or double AR for the purpose of our discussion. I make an application saying that I am a so and so dealer in the steel products, and I have a query, and I want to know what is the GST rate which is applicable to the respective steel product what I am selling. Then the authority for advance ruling will pronounce its decision. It will state the exact rate what it feels is applicable, and that will be binding. That means that rate only has to be followed by the applicant as well as the concerned officer or the jurisdictional officer. Therefore, this particular officer cannot again issue a notice to the respective taxpayer asking him to pay the tax at a higher rate, because the AAR has already clarified this by way of a ruling. Then it also avoids long drawn and expensive litigation at a later date. Seeking advance ruling is very inexpensive. Okay, if you have a doubt on any particular matter and you do not go to the AAR, you don't go to the authority for advance ruling, and you make an interpretation and you take a decision based on your understanding of the GST laws. Later, you may get a notice from the GST department. You have to justify to the GST department. If the department does not agree, you have to go for the appeal. If the appellate authority does not agree, you have to go to the tribunal. And if it is a question of law, again, you will have to go to the High Court or the Supreme Court to that extent. So therefore, this entire process will be avoided in case you go for an advance ruling, because advance ruling is inexpensive. Okay, it doesn't involve any appeal fees which is required to be paid or any tax demand which is required to be paid. The procedure is very simple and can be expedited easily, can be completed easily. So what it does is it provides the certainty and transparency to a taxpayer with respect to the issue, which may potentially cause a dispute with the tax administration. So therefore, this word is very important here. Potentially cause a dispute. Potentially cause a dispute. That means there may be a dispute which arises with the respective tax department, and on that issue, the advance ruling will give you the certainty and transparency. Again, a legally constituted body is therefore for advance ruling or double AR. It can give a binding ruling to an applicant who is registered under GST or who is desirous to be registered. Again, an important point here. You need not be registered for the purpose of applying to the AAR. You may not be registered to what you are supposed to do. Again, here also there is an appellate provision which is given. That means just because the advance ruling authority gives a particular decision, it is not necessarily final. Here also an appellate mechanism is given, wherein the taxpayer can apply to the AAR. AAR is nothing but appellate for advance authority, appellate authority for advance rulings. So he can apply to this particular AAR. And for this, again, there are timelines also which are specified for passing the order by both the AAR as well as the AAR. I hope you got the clarity here as to what are the basic, in brief, what are the basic rules with regard to the AAR and the AAR. So therefore, what are the objectives? This can be expected as a theory question. The broad objectives for setting up this mechanism or advance ruling is, first one is, as I told you, it to provide the certainty in the tax liability in advance in relation to an activity which is proposed to be undertaken by the applicant. That is, what is your tax liability if you undertake any particular supply or if you undertake any particular activity? What is the tax liability? If you want some certainty in that, you want some confirmation with regard to the same, in that particular situation, the advance ruling mechanism will ensure that the certainty in tax liability is provided. That is the first point. Second one is attract FDI, foreign direct investment, by ensuring the certainty in taxation aspect of transactions. Now, if any particular person is there in the US, he wants to invest in India. He is basically a software developer. He wants to develop a software and he wants to build that software in India. So in this particular situation, if he wants to know what is the GST applicability of software, rather than himself going through the law and arriving at a decision, to get a more conclusive proof, he can apply to the authority for advance ruling, and I can ask him what is the respective rate which is applicable to that particular product. And because of this, if he applies for this particular purpose and gets clarity, therefore there is a certainty in taxation aspect. You know what is the rate of tax applicable to your product. So therefore, since you know this, attraction of foreign direct investment becomes more. So a lot of foreign direct investments keep coming in because of this particular AAR, because it ensures the certainty in the taxation aspects. Then also reduces litigation. As I told you, litigation is a long drawn process in our country with regard to GST laws. So litigation means first he will send a notice, then he will ask you to pay something. You will say, no, I'm not expected to pay this. I will go on appeal. Then you have to pay the appeal fees. Then you have to file the appeal documents. Then the appellate authority will pass an order. You will not be happy with that order. Then you will go to the GST appellate tribunal. So this entire gamut of litigation will totally be reduced once the advance ruling mechanism is in existence. He can simply apply to the advance ruling authority, and once the advance ruling authority gives the decision, he has to follow that. Also, the pronouncing the rulings expeditiously in a transparent and is applicable to everyone, right from the person who is having a kirana and general store, because his turnover will be obviously more than 20 lakhs per annum, right from that person to a huge automobile showroom. Both are covered in the GST. So therefore, there should not be any confusion. Though the person who is into automotives may have a chief financial officer, he may advise the respective management as to what are the GST aspects. But when you look at a kirana and general store, he cannot afford a particular person to hire a particular person who is expert in GST. So what he can do is, rather he can do a one-time exercise of applying to the authority for advance ruling and get clarity on any particular decision which is made by the AAR. Okay, so therefore chapter 17, sections 95 to 106 of the CGST Act covers the provisions pertaining to the advance ruling, and also state GST laws also provide identical provisions with regard to the advance ruling. So therefore, all these particular provisions, it gives the matter relating to the advance ruling, and also state GST laws gives the identical provisions. So some definitions here which is relevant for us. What do you mean by the term advance ruling? What do you mean by the term advance ruling? It means a decision provided by the authority or the appellate authority or the national appellate authority. Now, national appellate authority, when it will come in this particular situation, where because authority of advance ruling will be appointed in each state. Let me take an example here. See, AAR will be appointed in each state. Okay, here if a similar case is present in, say, Telangana and Maharashtra, then two separate applications need to be made to the AAR. Now, if both the AARs give different views to the same case, then the NAA, that is the National Authority for Advance Ruling, will come into the picture. So I hope you understood what is this National Appellate Authority. Please bear in mind, this National Appellate Authority was nowhere there in the scheme of things till 2019. 2017, the GST law came. That time NAA, that is National Appellate Authority, was not there. But later what happened, when each particular person went for the advance ruling in different states for the same issue, there were differing rulings which were there. Differing rulings which were there. AAR of one state said that yes, this rate is correct. AAR of another state says that no, this rate is not correct. So this difference in opinion will come. So whenever this difference in opinion comes, you have to apply to the NAA, which is the National Appellate Authority, in this particular situation on matters or questions specified in the subsection 97(2), the sections we will see shortly, or 101 or 101C, in relation to the supply of goods or services, or both undertaken or proposed to be undertaken by the applicant. So therefore, I hope all of you understood what is the advance ruling. Advance ruling basically is a decision which is given by the authority. Authority is the AAR, or the appellate authority is the AAAR, or the NAA, National Appellate Authority, to the applicant on matters specified in these particular sections, which we will see now. In relation to the supply of goods or services, or both being undertaken or proposed to be undertaken by the applicant. Appellate authority is a very, very simple definition. It means the appellate authority for advance ruling, which is nothing but the AAAR referred to in section 99. And applicant means any person registered or desirous of obtaining the registration under the Act. Again, this is an important point which you have to remember here. Applicant can also be a person who is desirous of obtaining the registration. That means he is not registered at the moment, but he wants to get registered under the GST. Such person also can apply to the AAR. Fine. Application is again a simple definition. It means an application made to the authority under 97 subsection 1. Authority is nothing but the AAR, which is the authority for advance ruling referred to in section 96. So these were the definitions which we are going to cover. So now we come straight away to the main section, which says section 97, which speaks regarding the questions on which the advance ruling can be sought. Now, as I told you earlier, the advance rulings cannot be taken for all the issues whichever you feel it is relevant. The section gives particular issues on which you can go for the advance ruling, and only on those particular issues you can apply for the advance ruling. What are those issues? Let us see that. Before that, let me see. What does it mean by desirous to be registered? Good evening, Manisha. What does it mean? Desirous to be registered means wanting to be registered. Desirous to be registered means wanting to be registered. Okay, wanting means that is he's not yet registered, but he wants to get himself registered under GST. Before he wants to get registered under GST, he has some particular query for which he wants to apply for the advance ruling. Okay, I hope it is clear. So desirous means wanted to get the registration under GST. So therefore, what are the various issues on which questions on which the advance ruling can be sought? Again, as I told you, the advance definition of advance ruling is a broad one. So therefore, under the GST, it can be advance ruling can be obtained on a proposed transaction or as well as the transaction undertaken by the applicant. So therefore, in these two cases, the ruling can be undertaken either on a proposed transaction. That means the transaction is not yet been done. Before you undertake the transaction itself, you have certain queries for which you want some ruling to be made by the AAR. So therefore, proposed transaction also is covered here. Before that, you can apply to the advance ruling and get the clarification from the AAR, or it can also refer to a transaction which is already undertaken by the applicant. That means transaction is already over, but you can apply and see whether what you have done is correct or not. But please bear in mind, if you, after doing the transaction, if you are applying to the advance ruling and the advance ruling does not accept your version, it does not accept your interpretation, in that particular situation, whatever you have done on that, the respective damage has to be borne. That means if you are going for a tax rate clarification, you feel the tax rate is 12%, but the AAR feels it is 18%. You have already undertaken the transaction at 12%. Later, you are going to the AAR. If the AAR says that it is 18%, in that particular situation, the 18% only you have to pay. In that, whatever balance tax you have not paid, you will have to subsequently pay. So what are the various situations on which the advance ruling can be sought? First one, classification of goods or services or goods. Can anyone tell me what do you mean by the word classification? So I don't want the dictionary meaning. I want to know the meaning in GST. What do you mean by the term classification and why it is important? Please let me know your views. what is classification in GST and why it is important. What is classification in GST and why it is important? Any views? Yes, National Appellate Authority has come in 2019. If you go to the end of the study material, after the test questions, you will find the amendments which relate to the National Appellate Authority. There you will have all the respective points related to National Appellate Authority. Please refer to the last section of the study material after the test questions. You will find it. Okay. If it is not there in that, please download the material from the BOS website. In that you will find it. Yeah. So basic class HSN code, nature of goods services, HSN for rates, category of goods and services. Very good. So therefore, why is classification important? Classification, as I told you, is which good is what particular rate. There is a way in classification which is done as per the HSN harmonized system of nomenclature. Based on the HSN code, the rates are allotted. So therefore, if you have any particular doubts on how this particular good is to be classified and what is the respective tax rate which is applicable, in that particular situation, you can go for the advance. Second, applicability of any notification issued under the provisions of the CGST Act. What do you mean by the term notification? Again, in legal terms, a notification, not the dictionary meaning. What do you mean by the term notification? Why is the word notification important in GST? Notification. The word notification, why it is important in GST? So therefore, if I say notification is whenever there is any doubt with regard to any provision or the government wants to make some changes to the existing provisions, it will give a notification under the provisions of the CGST Act, and where this notification is applicable, from when it is applicable, for this purpose also the advance ruling can be taken. Then third one, determination of time and value of supply of goods or services or both. See, this is again a very, very critical thing. The time of supply, why it is important? Because that is the time on which you are supposed to pay the GST liability. Based on that particular time only, your responsibility of paying the tax arises. That is point number one. Now, when it comes to value of supply, what does it mean? It means what is the total value of supply on which you are supposed to pay the GST. Total value of supply on which you are supposed to pay the GST. That also is an important point. So time of supply as well as value of supply. On these two particular things, determination, how you have to determine what is the time of supply and what is the value of supply. If you have any doubts with regard to the same, you can apply to the AA. Admissibility of ITC of tax paid or deemed to have been paid. Now, all of you must be knowing this. Whether I can claim the input tax credit or whether I cannot claim the input tax credit. If you have a doubt whether this input tax credit is applicable or not. Now, one such doubt is a very common doubt is insurance of motor car or repairs to be done to the motor car, whether it is a eligible credit or ineligible credit. Later, the points relating to insurance and repairs were given in 17 subsection 5. The first time when 17 subsection 5, that is blocked credits, came into the law, at that point of time, the clarification was not given with regard to the repairs and insurance. So therefore, if you have this query, you can definitely ask and whether the input tax credit. This is a very, very common point where the people approach the authority for advance ruling, whether the admissibility of input tax. Many issues such as staff welfare. You are purchasing uniforms for the staff in your office and giving them. Now, whether on this the input tax credit is applicable or not. You are purchasing branded clothes for the staff. whether the input tax credit is applicable or not. On all these aspects, you can go on application to the authority for advance ruling. Then determination of the liability to pay the tax on any goods or services or both. This is nothing but the tax rate which is applicable, whether the goods or services are chargeable to tax or whether they are exempt for tax is something you can definitely question. Then whether the applicant is required to be registered. This is again a very common occurrence. Whenever you have doubts with regard to the threshold limit, whether you have doubts with regard to how to calculate the aggregate turnover, you can apply for to the advance. If a person has exempt turnover, it has taxable turnover, and it also has interest on fixed deposits. All these three put together cross 40 lakhs. Now, whether you are supposed to get yourself registered or not, these points you can definitely ask the authority for advance ruling. Now, whether any particular thing which is done by the applicant with respect to the goods or services amounts to or results in supply. That is the fundamental concept of supply by virtue of section 7. Now, whether it is supply or not, as per section 7, this also, whether it amounts to supply or not, you can check this particular point and you can check with the authority for advance ruling. Okay, so that these are some of the points which are there in section 97, where the questions for which advance ruling can be sought. Now, I want you to give your view in all these points. In all these points, there is a one very, very important topic in GST which is missed out here. One very important topic which is missed out here. I can give a clue also. It is the name of a chapter for you in CA final. That concept is missing. Can anyone tell me what is that particular concept which is missing from these particular points? GST Council's role is definitely there for the classification, but GST Council will give the necessary decision. But if you are confused about the decision, then only the advanced ruling will come into the picture, right? Yeah, and yeah, any query here? One important point which is missed out here, which is not covered under the advanced ruling. What is that? Can anyone tell? An important concept in GST, I can say. And also a very important topic from your exam point of view, which is not there in the list of items which you can cover in the GST. Place of sum. Very good, very good. Place of sum. Okay, exemption section 11 is very much there because you are clearly asking regarding the classification. Most of you got it right. Place of supply is not there. Now, why is place of supply not there? Because place of supply is an IGST law and advance ruling is there for each particular state. So therefore, when it comes to IGST law, therefore, there is no question of advance ruling because it is an interstate supply and IGST law is applicable. And here, if you see, for IGST law, there is no separate authority for advance ruling which is to be constituted. So therefore, place of supply will not be applicable in the above situation. Fine. So therefore, what are the matters which cannot be questioned apart from these, which are already in the proceedings in the case of the applicant in any of the provisions of the Act? That means what? Already there is an issue with regard to the tax rate, which is there in any proceedings in case of the applicant. The question is already pending for it is already in the course of an appeal. It is there. It is still pending. And the second one, the questions already decided in any proceeding in case of the applicant. So questions already pending, that you cannot question. The questions already decided, that also you cannot question. So these two matters you cannot question before the authority for advance ruling. I hope you got the clarity here. Now we come to the main appellate authority for advance ruling as well as the appellate authority for advance ruling. 96 and 99 cover these two. We will discuss both these things, authority for advanced ruling AAR and appellate authority for advanced ruling AAR. Fine. Again, whichever AAR is constituted under the provisions of the SGST or the UTGST Act, the same shall be deemed to be the authority for advanced ruling in respect of the state or union territory also. Okay. So therefore, whichever is constituted under state act, they will be the advanced ruling, there will be authority for the state act also. And here, a most important point here, if you look at the member of the advanced ruling, the government shall appoint officers not below the rank of the joint commissioner. That means the authority for advanced ruling, whoever is a part of that, should be a very experienced person who is able to interpret the provisions of the GST law, and officers not below the rank. So therefore, he has to minimum be a joint commissioner for being a member of the AAR. Same way, appellate authority for advanced ruling also, which is constituted under the SGST or the UTGST law, shall be deemed to be the appellate authority in the state or union territory also. Again, it can be seen therefore that both the AAR and the AAR is constituted under the state act and not under the central act. So this is an important point. Both these things are constituted under the state act and not the central act. So therefore, this will mean, again a very, very important point. This will mean that ruling given by the AAR will applicable only with regard to the jurisdiction of the concerned state or the union territory. If you go to a AAR of any particular state and if you apply for a particular ruling, it will be applicable only in that particular state and only to that particular taxpayer. So therefore, in these questions, that is why place of supply questions cannot be raised with the AAR. Okay. Again, a nominal fees is there, 5,000 rupees each towards the CGST and SGST in the prescribed form and manner. Whichever application, verification, all the relevant documents needs to be signed in the prescribed manner. And once the receipt of document application comes, the AAR will share the copy of the application to the concerned officer. After he does that, he will call for the relevant records. And after that, he will return it to the concerned officer as soon as possible. So application with 5,000 rupees fee should come. After the application, verification documents should be signed properly. After receipt of the application, he will send it to the concerned officer, whoever is the respective GST officer for the respective taxpayer. He will send it there and he will call for the necessary records and information, etc. And whatever records he is calling shall be returned to the concerned officer as soon as possible. Then after that, the AAR will examine the application along with the records. After hearing the applicant or his authorized representative, the AAR will pass an order either admitting or rejecting the application. So therefore, the AAR will either admit the application or reject the application. Fine. And also, as we already discussed, the application for advanced ruling will not be admitted in cases where the questions is already pending or deciding in any proceedings. In case or if pending proceedings is already pending or proceeding is already decided, in case of the applicant as per the provisions of the Act, in that particular situation, the applicant for application for advanced ruling will not be entertained in any particular manner. Again, in case the authority is rejecting the application, it will be done by way of a speaking order, okay, giving the reasons for rejection. And again, important point, the rejection cannot be made unless an opportunity of being heard has been given to the applicant. So opportunity of being heard has to be given. Only then the application can be rejected. Okay, opportunity of being heard to the tax applicant has to be given. After the order is passed, the copy of the respective order, which is either admitting or rejecting the application, shall be sent to the applicant and the concerned officer. On admission of the application, the AAR will pronounce its ruling within 90 days of the receipt of the application. So whenever the application comes, the time limit of 90 days is given to the AAR for pronouncing its ruling. And again, before giving the ruling, it will examine the application and further material placed before it or obtained by the authority examining the material should happen. And again, as I told you, before pronouncing the ruling, opportunity of being heard to the applicant or the authorized representative has to be given. Also, opportunity of being heard to the concerned officer or the authorized representative has to be given. Now, this is a very, very important point. If there is a difference in opinion between two members, now AAR has two members which are forming part of the authority. The authority will have two members. Now, if these two members are not getting convinced, both have different opinions, they will refer the point or points where they are differing to the AAR. They will refer it to the appellate authority for advance ruling for hearing that issue. Sometimes what will happen? The AAR also cannot come to the common conclusion relating to the points referred by the AAR. Then it shall be deemed that no advance ruling can be given in respect to the question on which difference persists at the level of AAR. Now, this marks a distinctive departure from what is there in your provisions relating to appeals. In the provisions relating to appeals, what does it say? It is referred to any other particular tribunal or any other appellate authority. And that those members and the members of the initial appellate authority, amongst that, whichever is the majority, that decision will be taken. But here that is not the case. In this particular situation, if there is no common conclusion, each member has a different view. In that particular situation, first what will happen? AAR will have two people. If they are not agreeing with each other, they will go to the AAR. If AAR also are not able to come to the common conclusion, each member has a different view with regard to the same, then it is deemed that no advance ruling can be given in respect of that question on which different persists. Then copy of the advance ruling duly signed by the member and certified shall be sent to the applicant, concerned officer, as well as the jurisdictional officer. So that was the procedure for obtaining the advance ruling. Now the next one is basically section 100 and 101, appeals against the AAR to the appellate authority. Now, when will the appeal be filed with the appellate authority? This particular point is given in this particular section. Now here, if the applicant is aggrieved with the finding of the AAR, okay, if the applicant feels whatever the AAR is found out, he is not happy with that, he can file an appeal with the AAR. He can file an appeal with the AAR. Similarly, if the concerned or jurisdictional officer does not agree with the finding of the AAR, he can also file an appeal with the AAR. So therefore, what happens here? Here, basically, if the applicant feels that he is not happy with the decision of the AAR, he can file an appeal with the AAR. If the concerned officer does not agree with the finding of the AAR, he also can file an appeal with the AAR. Again, this appeal, the time limit which is given is 30 days from the receipt of order of the advance ruling authority. Within this receipt of order, within 30 days, the appeal has to be filed. Again, another additional 30 days also can be allowed by the appellate authority for filing an appeal if they are satisfied that there was a sufficient cause for delay in presenting the appeal. So therefore, time limit given for appeal is 30 days from the receipt of order of the advance ruling authority. Additional 30 days also can be given where it's clear that there is a sufficient cause for delay in the appeal. This appeal has to be the prescribed form. Appeal has to be filed by the applicant along with the fee of 10,000 rupees each under the CGST and SGST. Again, but in this particular situation, if the concerned officer or the jurisdictional officer is aggrieved with the decision of the AAR, they need not pay any particular fee. So that means if the department, the officer goes on the appeal in that particular situation, no fee is required to be paid. Fine. So that was the provisions with regard to the appeals to the appellate authority. Here, the appeal, whatever verification that is contained and all the relevant documents in this particular situation shall be signed in case of the concerned officer by that officer authorized in writing by such officer, and in case of an applicant in the specified manner. Fine. So therefore, whatever documents, appeal, etc., will be signed here. In case of the officer by that particular officer, or in case of the applicant, whichever specified manner. Once the appellate authority hears both the parties, the appellate authority shall pass the order within a period of 90 days of filing of the appeal. So therefore, this period is 90 days. Within 90 days of filing of the appeal, the order will have to be passed. Again, here what happens, if you see here, if the member of the AAAR, very, very important point, if the member of the AAAR differ on any particular point, it is deemed that there is no advance ruling which can be issued in respect of the question under appeal. Again, which the said authority can pass such order, either confirming the ruling which is given by the AAR, or nullifying, modifying the ruling which is done by the AAR, appealed against in respect of difference of opinion. Whichever copy of the advance ruling which is given by the appellate authority, members have to be signed that, certified in the prescribed manner, and communicate to the applicant, the concerned officer, jurisdictional officer, and the authority. So these are the procedures with regard to the appellate authority for advance ruling. Now this 101A, again, this particular 101A refers to the constitution of National Appellate Authority for Advance Ruling. Now, this was this came to the provisions in the year 2019, when initially GST law was there. This particular point, National Authority for Advance Ruling, was not there. This came into the picture later. So, what does this say? The government shall, on the recommendations of the council by notification, it will constitute from such date as may be specified an authority known as National Appellate Authority for Advance Ruling for hearing appeals made under 101B. What is 101B? Which we shall see soon. So, National Appellate Authority for Advance Ruling, that is the NAAR or NAA for short form, will be constituted for hearing the appeal under 101B. Now, this constitution of NAA is very, very important. It will have highly qualified and intellectual people, because these are the situations where there is a disagreement between two authorities for advance ruling. So therefore, what is the decision to be made? That person who is making that decision has to be very competent. So therefore, who shall it consist of? It shall consist of the president, who is the judge of who has been a judge of the Supreme Court, or is or has been the Chief Justice of a High Court, or has been a judge of a High Court for a period of not less than 5 years. So the president of the NAA, the president will be appointed. This president can be either a Supreme Court judge, he can be the High Court Chief Justice, or the judge of the High Court for a period of not less than 5 years. Second is a technical member from the center's side, who is or has been the member of Indian Revenue, that is Customs and Central Excise, Indian Revenue IRCCS, that is Indian Revenue, whoever is officer group A. Group A is basically the main group with which talks about the commissioners, joint commissioner, etc. And he has completed at least 15 years of service in Group A. Group A is the top level, that is the commissioner level. 15 years service he has to complete that. Then the technical member from the state side, who is or has been the officer of the state government, not below the rank of the additional commissioner of VAT or state tax, with at least 3 years of experience in administering the existing law or the SGST in the fields of finance and taxation. So therefore, these shall be the members of the respective NAA, is the president, the technical member center, the technical member state. Fine. I hope this point is clear. Who shall be comprising the part of the National Appellate Authority? Now, The president shall be appointed by the government after consulting with the Chief Justice of India or his nominee. Fine. Who shall appoint the president of the NAA? The NAA president will be appointed by the government after consulting the Chief Justice of India or his nominee. Sometimes there will be a vacancy. The provision is given with regard to the vacancy. If there is a vacancy in the office of the president by reason of death, resignation, etc., the other senior most person of the NAA shall act as the president until the date on which the new president will be appointed. The new president appointed enters the office. Sometimes what happens, the president will not be unable to discharge his functions due to absence, illness, or any other course. In that case also, the senior most member of the NAA shall discharge the functions of the president until the date on which the president resumes his duties. Again, so that was basically the appointment of the president. Now the next point number 4 in 101A talks about the appointment of the technical member center. Technical member center qualifications we have already seen. So therefore, the technical member center as well as the technical member state shall be appointed by the government on recommendations of a selection committee. So there is a selection committee which is appointed, consisting of members in the manner as may be prescribed. They will appoint the technical member center and state. Again, just because there is a vacancy or defect in the constitution of the selection committee, just because of that, you cannot say the appointment of the members of the NAA is invalid. So therefore, once the selection committee is constituted, whoever they appoint as the technical member center or state shall be valid. Just because there is a vacancy or the selection committee does not have the ideal number of people, you cannot say the appointment shall be invalid. Now, again, an important point here is the one important point which the government should keep in mind before appointing the president or the technical members is that the government should satisfy itself that such person does not have any financial or other interests which are likely to prejudicially affect the functions as such president or the member. So therefore, whichever the respective person is being appointed, he should not be, say, a director in any company which is applied for the to the advance ruling, where he can have a way in which he can his decision is influenced. Okay, so therefore such interest, or he should not have a huge share in any company which is applying for the advance ruling. So all this you have to carefully take care before you are appointing that particular person. So salary allowances, terms and conditions for the president and the members shall be such as may be prescribed, provided neither salary and disallowances nor terms and conditions shall be varied to the disadvantage after appointment. That means once you agree to the respective salaries and terms and conditions of the service, after they are appointed, you cannot change those salaries and terms and conditions. So once you have agreed it, you have to stick to that. You cannot vary the respective salary terms and conditions to their disadvantage. Again, now this talks about the term of office. Term of office. That means the president shall hold the term for 3 years from the date on which he enters or until he attains the age of 70, whichever is earlier. So whenever he comes into the office, from that time 3 years or till he becomes 70 years, whichever is earlier, and he shall be eligible for reappointment. He shall be eligible for reappointment. So this talks about your member in which the respective office is to be held, and what is the term of office. So tenure of 3 years from the date when he enters or till he becomes 70 years, whichever is earlier. Now, this technical member center or the technical member state shall hold office for a period of 5 years from the date from which he enters upon office or until he becomes 65 years, whichever is earlier. Now here, the difference between these two, president is term of 3 years or until he attains 70 years, whichever is earlier. Technical member will be 5 years from the date he enters or until he attains the age of 65 years, whichever is earlier, shall be eligible for reappoint. Again, the president or member by any notice in writing, he can resign whenever he wants. That is, whenever the president or member wants to resign, he can give a notice in writing under their hand addressed to the government, can resign from the respective office, and provided that the president or member shall continue to hold the office until the expiry of 3 months from the date of receipt or until a person duly appointed a successor, whichever is earlier. So therefore here what does it mean? It says that the president or member will continue to hold the office till expiry of 3 months from the date of receipt of notice. So whenever the notice is given to the government, whenever the government receives the notice from the date of receipt to 3 months, or till any other particular person is appointed as a successor, as the next particular point. In this particular situation, you will have to, whichever is earlier, has to be taken into consideration. I hope this point is clear. Right? This was basically the tenure of the president and the technical members. Again, the study material, again, please refer to the last page after test questions. All those provisions are covered there. I have again put it in the matter itself so that it becomes easy for you when you revise. You don't have to go to the end and read it. Please refer to the end of the study material after test questions. All the provisions with regard to your National Appellate Advanced Ruling is mentioned there. I have mentioned here for your ease, and so that you can easily refer these particular. I go as per the flow, because after you study everything, then your mind, you will be very tired and exhausted. Again, if you see one fresh section, you won't feel like studying. So that's why I have included the section here itself, so that you can easily go through it through the course of discussing the provisions. Fine. So that was resigning, tenure, etc. Now we come to removal of office. Sometimes the government may also, after consultation with the Chief Justice of India, may remove from office such president or member who has been adjudged as an insolvent. That is, he has no money, he is bankrupt, so therefore he is adjudged as an insolvent. That member can be removed. Or who has convicted of an offense, which in the opinion involves moral turpitude. That means mens rea, intention to make an offense, intention to commit an offense is there, for which he has been convicted, can remove it. Then he has become physically or mentally incapable. Some issues are there, mental issues are there, due to which he is not capable of acting as a president or the member, or he has acquired any other financial or other interest which is prejudicially affecting his functions as a president or the member, or he has abused his position. When I say abused his position, he has made certain decisions which are not correct. Okay, and due to this, he has rendered his continuance in office. He has rendered his continuance in office prejudicial to the respective public interest, provided the president or the member shall not be removed on any of the grounds specified in D and E. So D and E, these particular grounds, he has to be informed of the charges, an opportunity of being heard has to be given. So when he has acquired the financial or other interest, or he has abused his position, you cannot remove it unless you are informing the charges against him and also given an opportunity of being heard. Fine. So that is there. And also, without prejudice to the provisions of 11, you cannot remove the president and the technical members from their office, except the order made by the government on account of proven misbehavior or incapacity after inquiry made by the judge of the Supreme Court, nominated by the Chief Justice of India on reference made to the government, and such president or member has to be given an opportunity of being heard. So therefore, whatever sub-provisions of section 11 say, you cannot remove the president and technical member from the office. Order has to be given by the government. There should be proven misbehavior or incapacity after inquiry made by the Supreme Court judge. The Supreme Court judge has to be nominated by the Chief Justice of India on the reference made to the government, and such president or member should be given an opportunity of being heard. Then suspension also happens wherever the reference is being made under 12. The government, with concurrence of the Chief Justice, will suspend the respective president or technical members. Also, Article 220 talks about whenever a particular member assumes a judicial post, later whether he can act as a person, as an authorized representative. Subject to those rules, the president or the members on ceasing to hold their office, you are not eligible to appear, act, or plead before the NAA where he was a president, or as the case may be, a member. That means if you are a president or a technical member of the NAA and you are no longer continuing to be in office, you will not be eligible to reappear, act, or plead before the NAA where he was the president, or as the case may be, a member. Fine. So that was your procedural aspects with regard to 101A, which talks about the constitution of the NAA. 101B again speaks about the provisions relating to appeal to the National Appellate Authority. So any queries still here? Bill was passed to increase the age limit of the GST Appellate Tribunal President. Yes. So now coming to the main important point here is 101B, when the appeal is to be undertaken. I'm not able to see. Problem with my mouse. Just give me a minute. Yeah. So what are the appeals? So with respect to the questions mentioned in 97 subsection 2, where conflict, so basically what is 97 subsection 2, which was saw the list of issues against which you can go for an advance ruling. Now with respect to such issues where conflicting advance rulings are given by the appellate authorities of two or more states or union territories, or both under 101 subsection 1 clause 3, which talks about the decision of the appellate authorities. In this case, any officer authorized by the commissioner or an applicant being a distinct person referred to in section 5025 aggrieved by such advance ruling may prefer an appeal to the National Appellate Authority. Can anyone tell me what you mean by the term distinct person, which is referred to in section 25? Can anyone tell me what is this distinct person as referred to in section 25? Distinct person. What do you mean by this term distinct person? Distinct person. Distinct person. Yeah, same PAN, GST number, different, residing in different states. So, distinct person may be a related person or establishments of registered person in two different states having the different GST numbers. So, therefore, establishment of a registered person in two different states having the different GST numbers. That is your distinct person. So, what happens when you can go for the advance ruling? When you can go for the advance ruling? In this particular situation, here with respect to the questions, again, important point here is the question should be the same as what is given in 97 subsection 2. You cannot exceed that. Conflicting advance rulings are given. So advance ruling on one particular state gives one ruling, other gives another ruling. Or any officer authorized by the commissioner or an applicant being a distinct person referred to in 25, aggrieved by such advanced ruling, may prefer an appeal to the National Appellate Authority. This is what it says. Now, if you look at an example, what does this mean? Okay, first here, advanced rulings with respect to rate of tax on steel. State ARR says it is 12%. State BAR says it is 18%. Therefore, if this confusion is there, either officer or distinct person referred to in 25, in section 25. Okay, so therefore, of I will say here A enterprises, okay, having GST number in state A and state B. In apply, this distinct person has GST number in state C, can apply to NAA. This is what it is, right? He can apply to the NAA, to the National Appellate Authority, right? Again, when with respect to the officer authorized by the commissioner, this officer authorized by the commissioner should be from the states in which such advance ruling have been given. So therefore, the officer who can apply to the National Appellate Authority shall be from the states where such advance ruling has been given. Then every appeal under this section shall be filed within a period of 30 days from the date on which the ruling sought to be appealed against is communicated to the applicant's concerned officer and jurisdictional officer. So 30 days time limit is given for the appeal to be preferred to the NAA. Provided the officer, whoever is authorized in this particular situation, period of 90 days is given from the date on which the ruling is sought to be communicated to the concerned officer or the jurisdictional officer. Again, there is a subsequent provision which is there. This time limit, if the NAA is satisfied that the appellant was prevented by sufficient cause for presenting the appeal within the 30-day set period, or as the case may be 90 days, he may allow such appeal to be presented within a further period not exceeding 30 days. So therefore, condonation provision is given here also. If he is prevented by sufficient cause for presenting the appeal, he can give another 30 days time limit to the applicant, and for the officer who is giving, he can give another 90 days to the officer. Apart from that 90 days, extra 30 days can be given for the applicant. Apart from the 30 days, another 30 days can be given. Now, this period of 30 days or 90 days shall become counted from the date of communication of the last of the conflicted rulings to be appealed against. So what does this mean? Last of the conflicted rulings means if state A gives ruling on 20th November 2023, state B gives ruling on 6th December 2023, 90 days, 30 days or 90 days to be reckoned from 6/12/2023. So therefore, this is an important point. Date of communication of the last of the conflicted rulings has to be taken into consideration. Again, every appeal under this section shall be in such form, accompanied by such fee, verified in such manner as may be prescribed. Fine. I hope you are understanding this point. It's a new point. Since 2019, it is applicable. So now we come to 101C, which speaks about the order to be passed by the NAA. Here what happens, the NAA first will give an opportunity of being heard to the applicant and also to the officer authorized by the commissioner, all the principal chief commissioners, etc. After that, giving an opportunity of being heard, it will pass an order as it may think fit after either confirming or modifying the rulings which are appealed against. If there is a difference in opinion between the members of the National Appellate Authority, it shall be decided in accordance with the opinion of the majority. Now, this is again also a departure from what was mentioned with regard to AAA. Here what it says, opinion of the majority is important. So therefore, if there is a difference in opinion between the members of the NAA, it will be decided as per the opinion of the majority. Again, this particular order shall be passed as far as possible within a period of 90 days from the date of filing the appeal, again under 101B. Again, this 90 days time limit, whichever is there, is not a hard and fast rule. It is an advisory time limit which is given. So whichever order is supposed to be passed, they have to pass within a period of 90 days from the date of filing of the appeal. So whichever copy of the advance ruling, whichever is passed by the NAA, will be duly signed by the members, certified in the manner as may be prescribed, shall be sent to the applicant, the officer authorized, and all these particular persons, and also to the authority or appellate authority as the case may be after such pronouncement. Fine. So therefore, again, section 102 is rectification of mistakes. Again, the amendments to these sections are given at the end of the study material after the test questions. In the basic provisions, you will the word of National Appellate Authority will be missing. So, but that has also been added. So, what does this do? It gives the law to the section 102, gives the law to the AAR, AAR, and the National Appellate Authority to amend the order to rectify any mistake apparent from the record within a period of 6 months from the date of the order. So, within a period of 6 months from the date of the order, whatever order has been passed by either of these three authorities can be amended. Can be by this, whichever order has been passed by any one of these three authorities can be amended. Such mistake, again, either the authority can see by itself on its own record, or it can be brought to the notice by the concerned applicant or the respective jurisdictional officer. If the rectification has the effect of enhancing the tax liability or reducing the quantum of input tax credit, the applicant must be given an opportunity of being. So because of this rectification of order, there is an impact of increasing the tax liability or reducing the quantum of input tax credit. Opportunity of being heard has to be given to the applicant. Okay. These are some of the important points. And 103, this is a very, very interesting point, very, very important point from examination point of view. Applicability of advance ruling. Any advance ruling which is pronounced by the AAR or the AAR shall be binding on the applicant and on the concerned officer or the jurisdictional officer in respect of the applicant. So therefore, order which is passed by the AAR or the AAR will be binding only on the applicant and on the concerned officer or the jurisdictional officer. So that means advance ruling is not applicable to similarly placed other taxable persons. It is only limited to the person who has applied for the advance ruling. So what does this mean? Again, let's take an example. Mr. A of state A sells steel products and has applied to the AR with regard to the clarification on rate applicability. Okay. State A clarifies that the GST rate is 12%. Now, Mr. B of state B sells the same products as Mr. A. Thus, the advance ruling. So here what happens? So whatever A is filing, so that means advance ruling passed on Mr. A shall not be applicable to Mr. B. Fine. So therefore, it shall be binding on only on the applicant and on the officer or the jurisdictional officer in respect of the applicant, he says. That means even if the ruling is given for the officer has preferred an application and the ruling is being given, it will be bound only on that respective concerned officer or the jurisdictional officer in respect of the applicant. Now that officer may have multiple similar cases. This ruling will not be binding on him for all that, only on the as far as the applicant is concerned. So therefore, another important point, it is advance ruling is not applicable to similarly placed other taxable persons in the state also. It is only limited to the person who has applied for the advance ruling. That means what? This whatever advance ruling is there, if more than one taxable person in the state, in the same state, in the example what I gave, they were in different states. But take for example, both the taxable persons are in the same state, they are facing the same issue. In that particular situation also, the ruling will be applicable only on the applicant who has applied for the advance ruling and not on the other person, even though he is from the same state. Right? I hope you got this clarity. Again, there is no fixed period which says that this ruling has been given. It will be applicable only for 3 months, 4 months, nothing like that. So, advance ruling will be applicable, shall be binding till the period when the law, facts or circumstances supporting the original advance ruling have not changed. That is, rate of steal will be 18% only what the advance ruling says. Later, if the government makes it 12%, in that particular situation, the advance ruling is no longer applicable because the law, facts or circumstances which are supporting the original ruling have not been changed. Fine. That is an important point which you have to remember. Now we say the advance ruling applicability, it shall be binding on who all. The advance ruling which is pronounced by the National Appellate Authority shall be binding on the applicants being the distinct persons who had applied for the ruling and all the registered persons having the same PAN number. That means whichever distinct person has applied for the advance ruling, it will be applicable on him, and not only him, but all the registered persons having the same PAN number, it shall be applicable to them also. It shall be binding on the concerned officers and jurisdictional officers in respect of the applicants referred to in clause A. So in respect to the applicants, to the jurisdictional officer it will apply, and also the registered persons having the same PAN number, which is nothing but the distinct person. 104 again speaks about the situations and circumstances where the advance ruling is to be null and void. So what are the circumstances under which it be considered as void and will lose its binding value? Where the authorities, that is either the AAR or the AAR or the NAA, has found out that the advance ruling has been obtained by the applicant or the appellant by fraud or suppression of facts or misrepresentation of facts, it may by order declare such ruling to be void ab initio. That means if these three authorities finds that the whatever advance ruling is being given is obtained by the respective applicant by fraud or suppression of facts or misrepresentation of facts, it may by order declare that whatever ruling has been given is void ab initio. That means it is straight away null and void. So therefore, all the provisions of the CGST Act will be applicable as if such advance ruling has never been made. But whenever the advance ruling was given and up to the date on which it was found that it was null and void, for this period, it shall be excluded. That means for this period, the advance ruling will definitely be applicable. But later that, all the provisions will apply as if such advance ruling was never be given. Also, whenever an order for passing the advance ruling which is to be void can be passed only after hearing the applicant or the appellant, the copy of the order which is made shall be sent to the applicant, the concerned officers and the jurisdictional officer. Fine. I hope this is clear. So that was your void ab initio circumstances. Now we come to the powers and procedures. Powers and procedures of these three authorities, that is the AAR, the AAR and the National Appellate Authority. Again, these authorities are vested with the powers of a civil court under the Code of Civil Procedure, where it comes to discovery, inspection, forcing the attendance of any particular person, examining such person on oath, issuing commissions, and also compelling the production of books of accounts and records. So same to the other appellate authorities what we discussed in the previous session. Both authorities are deemed to be civil court, but they are not civil courts for the purpose of code of criminal procedure. As far as section 195 of that is not very relevant from examination point of view, but one section it is considered to be the civil court, and later it is for the particular section it is not considered. Then whatever proceedings is made before the authority shall be deemed to be a judicial proceeding under 193 or 228 for the purpose of 196 of the code. Again, these both authorities have the power to regulate its own procedure. So with this, we come to the end of this chapter, very, very small chapter. Important points in this chapter is the National Appellate Authority, because it is a recent amendment. When I say recent, it is done 4 years back, that also. It's not very recent, but you can expect some questions based on that. Now let us try to work out one problem. Mr. Ranjan intends to start selling certain goods in Delhi. However, he is not able to determine the classification of goods proposed to be supplied by him. Okay, as the classification is contentious, there is different opinions with regard to that. And also the place of supply, if he supplies the said goods from Delhi to buyers in US. Ranjan's tax advisor has advised to apply for the advance ruling for the issues. He told Ranjan that the advance ruling would bring him certainty and transparency in respect of litigation. He agreed, but has some apprehensions. You are required to, Ranjan, with respect to the following. Number one, tax advisor asks Ranjan to get registered under GST law before applying for the advance ruling, as only a registered person can apply for the same. Whether Ranjan needs to get registered. Please try to answer this first question. Yeah, so therefore in this particular situation, if you see, there is no requirement of the registration to be compulsory. A person who is desirous of getting registered under the GST also can apply for the GST registration. Okay, so therefore in this particular situation, even a person desirous of obtaining the GST registration can also apply for an advance. Okay, a person desirous of obtaining the GST registration can also apply for the advance ruling. Therefore, Ranjan need not be registered. Ranjan is apprehensive that if at all advance ruling is permitted to be sought, he has to seek it every year. Whether Ranjan's apprehension is correct. Whether Ranjan's apprehension is correct. Any answers for this? So here if you see, he did not apply it every year. It will be very much valid unless the laws, facts and circumstances associated with the case changes. In this particular situation only, he cannot apply. But as long as the law does not change, he need not apply it every year. So therefore, in this particular situation, there is no time limit on the binding of the advance ruling which is given. The advance ruling is binding on the respective taxpayer till the laws, facts, and circumstances associated with that ruling changes. Till then, it is very much applicable. The tax advisor is of the view that the order of authority for advance ruling is final and not appealable, whether the tax advisor's view is correct. Please try to answer point number 3. Yeah. So in this particular situation, the tax advisor's view is not correct because he can very much appeal with the AAAR, that is the Appellate Authority for Advance Ruling, with regard to the decision which is passed by the AAR. The next one. Sambhav Ranjan's friend is a supplier registered in Delhi. He is engaged in the supply of the goods which Ranjan proposes to supply at the time at the same commercial level that Ranjan proposes to adopt. He intends to apply the classification as decided in the advance ruling order to be obtained by Ranjan to the goods supplied by him in Delhi. Whether Sambhav can do so. Whether Sambhav can do so. Answers for this? Not you should not say not every advanced ruling are different. That should not be the reason. The reason is the advanced ruling which is pronounced is binding only on the case where the applicant has filed that respective application. Even though in the same state there is a different person, it will not be applicable to him. And also in different states, if it is there, it will not be applicable to them. So in both the cases, he cannot apply for the respective advance ruling. So therefore, in this particular situation, he cannot do so because advance ruling just given to another person will not necessarily be applicable to them. So with this, we come to the end of the chapter with regard to advance ruling. A short break here of 10 minutes, and then post this we will look at the another small chapter which refers to the liability to pay the tax in certain cases, that is with regard to merger, amalgamation, and various things. So we the respective topic. I will see you. I will just take a short break and I will see you after 10 minutes. Good evening. Welcome back, everyone. I saw uh, the two questions here. If distinct person, can they adopt the same ruling? Distinct person will only be able to adopt the ruling in case of the appeal which is presented to the National Appellate Authority, not with regard to the AAR and the AAAR. How to present answers in laws language? Please tell us. Also, how to correct our answers in from. I get only 40 marks in IDT because of poor presentation. So what I would suggest, Geeta, if you can send me, if you have your answer sheets, I don't know whether you have applied for the answer sheets from the ICAI, because I want to know how you are presenting. If I'm able to see that, if you can send me the photos, I'll give my email ID also. If I can send you the photos, how you are presenting, in what way improvements can be done, definitely I will suggest so that you can improve it. If you look at the answers given in the study material, that's a very elaborate way of presentation. You need not actually give the answers as per that. The answers given in the study material is slightly more elaborate due to a reason, because you need to understand the answers properly. That is why the respective section is given and the various other associated topics or concepts are also covered. But here in this particular situation, whenever any question is asked, first of all, you need to give the reference to that section. You need to give a brief about the section. Again, as I've told you before also, there is no requirement of mentioning the section number in the examination. You can just write according to the provisions of the CGST Act 2017 in case you are not able to remember the section. So give reference to that section and what that section says. And after that, what that case says, give a brief about that. And then post that, give your concluding remarks and your answer. So if you look at the example of that question, which speaks about that question what we covered. The tax advisors asked Ranjan to get registered under GST law before applying for the advanced ruling, as only a registered person can apply for the same, whether Ranjan needs to get registered. Straight away draw reference to the provisions of the advanced rulings here, that according to the provisions of the CGST Act 2017, this is how your answer should start. The advanced ruling can be obtained by any person who is registered or any person who is desirous to get himself registered. Therefore, in this particular situation, the tax advisor has asked Ranjan to get himself registered before applying for the advanced ruling. But since this section also covers a person who is desirous to obtain the registration, the opinion given by the tax advisor is incorrect, and therefore Mr. Ranjan need not get himself registered in order to apply for the advanced ruling. This is exactly how you present your answer. Not much complications. 3 points keeping in mind. First point, give reference to the provisions which cover the question. Number 2, give reference in brief to the facts of the case. Number 3, give your opinion and the answer, whatever you feel is correct. These 3 steps, if you are able to follow, then you will be easily able to get very good marks. Also, please send across your answer scripts or your answers, what you have written. Definitely, IDT is a very, very scoring subject. It is a subject which in group 2 can mobilize your aggregate a lot. It is a very scoring subject purely because you are very lucky that the VAT excise duty is no longer there, service tax is no longer there. You don't have many judicial precedents as such. You'll be tested mostly on the concepts and the interpretation. Since there is no case laws issue here, it's a very, very scoring subject. You need to aim to get at least 70 to 75 marks in the indirect taxes, so that your other complicated subjects, I mean, it's not complicated, income tax is there, but it is very vast. You never know from where the question will come, because the judicial precedents are many and the case laws are many. So from anywhere the question can be asked. So wherever you have a lesser marks, this will help in adjustment, and therefore your aggregate will shoot up. So definitely I would suggest you to focus at IDT as a very, very scoring subject in this group 2 scheme of things. Now we come to the next topic, which refers to the liability to pay the tax in certain cases. It's a very small topic which speaks about the various situations wherein due to some situations, what happens to the liability to pay the tax. Wherein situations like merger of 2 companies, situations like death of a particular person, situations like amalgamation, right? In these particular, or discontinuance of business, partition of HUF, okay, or association of persons. So this particular topic covers the various situations where there is a change in the constitution of the respective business and the respective tax needs to be paid accordingly. Okay, so therefore, what happens here is for certain transactions like liquidation, business transfer, etc. Part liquidation, business transfer, partition of HUF, amalgamation or merger, it is very difficult to determine the liability to pay the outstanding tax, interest, penalty, or any other dues. Because in the what do you mean by liquidation? When the company is closed down, when the company is closed down, and all the settlement is being done by the respective company to all the others. In that particular situation, what is to be done? Right? In that particular situation, what is to be done is who has to pay the tax. That is the main question which you have to take care here. So that particular questions have to be answered here. In such situations, it's very difficult to determine the liability to pay the outstanding tax, interest, etc. So section 85 to 94 of the CGST Acts, it talks about the persons who is liable to pay the tax under certain specified transactions like liquidation of the company, transfer of business, etc. State laws also have IGST identical provisions, and also IGST also has similar provisions by virtue of section 20 of the IGST Act. So before we go to the respective provisions, let us look at certain definitions. Agent. Now, what do you mean by agent? In simple terms, agent is basically referred to any particular person who is appointed by another person to carry out his business activities on his behalf. That is referred to an agent. It's a very, very simple definition. So agent means what? It means a person, including a factor, broker, commission agent, bill creditor, auctioneer, or any other mercantile agent, by whichever name called, who carries on the business of supply of receipt of goods or services, or both, on behalf of another. So on behalf of another person, if any other particular person carries on the business of supply or receipt of goods or services, such person is basically an agent by virtue of 2 subsection 5. Why is an agent relevant in this particular discussion is when I speak about an agent, he is representing another person who in common terms is also known as a principal. So when I say agent, when he undertakes the supply on behalf of the principal, who is liable to pay the tax? That is why this word agent is important. And in such situations, who is the person liable to pay the tax, we will have to see. That is where we will look at this particular concept. So similarly, as I told you, just as how an agent is there, what do you mean by the term principal? Principal means a person on whose behalf an agent carries on the business of supply or receipt of goods or services or both. So a person on behalf of which the agent carries on the business of supply or the receipt of goods or services or both, he is known as a principal. The commissioner means what? Commissioner means the commissioner of central tax and includes the principal commissioner of central tax appointed under section 3 and also the commissioner of integrated tax appointed under the IGST. So who is the commissioner? So commissioner definition also is very, very simple. Business definition has been covered before also, I think, in your other concepts of supply and time of supply, value of supply. In the first chapter, first 2-3 chapters of GST itself, you will have the provisions relating to the definition of business. The same definition is there, so it will be more like a revision for you. Trade, commerce, manufacture, profession, vocation, adventure, wager, or other similar activity, whether or not it is for a benefit. Okay, just go through this definition. I'm sure you have read this definition multiple times. And so anything, any trade, commerce, manufacture, profession, vocation means skill for doing anything, adventure, wager, or similar activity is whether or not it is for a pecuniary benefit. So whether or not it is for a substantial benefit, that is not the consideration. So any of these activities or any activity or transaction in connection with the above. Also, C is any activity or transaction in nature of A above, whether or not there is volume, frequency, continuity, or regularity. So it does not matter whether volume is high. It does not matter whether there is a frequency, continuity, or regularity. So even one particular activity, it can be termed as a business. Then supply or acquisition of goods, including capital assets and services in connection with commencement or closure of business. This also, whenever you are acquiring the capital assets, when a business is being closed, some other person is acquiring. And when you are commencing a business, you are acquiring the capital assets, that also. Then provision by a club, society, or any other body for a subscription, the facilities or benefits to the members as the case may be. So whenever there is a club, association, etc., it is providing facilities to the member. This was a very litigative topic in service tax earlier, which is now not that relevant, because it is straight away included in the term business as well. So whenever there is a club, association, etc., where you're a member of that club, you are giving subscription for that, you are getting some services, it is a business. Admission for consideration of a person to any premises. So if you are paying any money for getting admitted to a premises, like going to a movie, going to an exhibition, etc., that also is there. And services which are supplied by the person as the holder of an office, which has been accepted by him in the course or further. So if any person is the chairman of any particular public sector company, corporation, etc., such services being provided, that is business. Activities of a race club, including your totalizer, license to bookmaker, etc., that is there. Then any other activity or transaction undertaken by the central government in which they are engaged as public authority. So these are all the various concepts, various points which are covered in the definition of the term business under 2 subsection 70. Now we move on to the next the section which is here. First case what we are going to see is liability to pay in case of transfer of business. So whenever a business is getting transferred, what is the liability to pay? How to explore? I meant to say, should we read case laws, judgments on daily basis? There is booklet available issued by by GST committee. Should we start reading? See, the GST committee of ICAI issues the publications for the members in practice, mainly with a more practical approach to the respective GST law. My suggestion would be to first look at the study material very, very clearly, the respective changes, respective amendments, the supplementary papers which are given. Please look at these points first. And after, of course, you can read the booklet which is given in the CA website. That is all we all have read in the past. It has been developed by a bunch of very expert people, expert persons by the Indirect Tax Committee of the CA Institute. But again, I would suggest you to first qualify, and you can read that for knowledge purposes. But please make sure that you do not get confused, because that literature which is there in that book is more of an advanced level. So by reading that particular booklet, you should not get very tense and see it is that very complicated and all of that. Rather than that, first focus on the study material. If time permits, if you have a genuine interest towards the subject, if you want to pursue a career in GST, definitely the booklet is very useful. But my suggestion would be first look at your study material and develop the proper strategy of getting a very good score in indirect tax, as I told you, somewhere in 70 to 75 marks range. And then, of course, after you qualify as examination, you can read a lot of literature, because it's a huge subject. It is a developing law, and a lot of new developments. Every meeting of the GST Council, a lot of multiple things are decided upon. Then you definitely have to read those books. You have to keep yourself updated with regard to all the concepts which are there. So therefore, liability to pay the tax in case of transfer of business. So what does it? So when a taxable person who is liable to pay the tax under the CGST transfers his business, this includes transfer or change in ownership due to death of the sole proprietor also. So in whole or in part, by sale, gift, lease, leave and license, hire, or in any other manner whatsoever. So any particular taxable person who is liable to pay the tax under the CGST, he transfers his business. Okay, he transfers his business. Again, this can be the transfer of business due to change in ownership, and this can also be the transfer of business due to death of the sole proprietor in whole or in part, by sale, gift, lease and leave and license, hire, or in any other manner whatsoever. In this particular situation, if he transfers his particular business, then the taxable person and the person to whom the business is transferred shall jointly and severally be liable. This is a very, very important point. Okay, jointly and severally be liable, wholly or to the extent of the transfer, to pay the tax, interest, or penalty from the taxable person up to such point of time of transfer, whether such tax interest has been determined before such transfer but has been remained unpaid, or is determined thereafter. So what does that mean? So here the taxable person is there. What he has done due to death or due to change in ownership, what he has done is he has gone ahead and he has transferred his business. So whenever the transfer of business happens, the taxable person, whoever is transferring the business, and the person to whom the business is transferred, they both shall be jointly and severally liable, okay, or to the extent of the transfer to pay the interest. So both shall be liable. Both shall be liable. Okay. Till when they'll be liable? Up to the time of such transfer. Okay. They'll either be liable to the tax, interest, and penalty which is determined before, which is before the transfer. You know what is the tax, interest, and penalty liable. It is determined before, you have not paid, or which has remained unpaid, or it is determined afterwards. That is after the transfer, the determination has happened. Right. And then where the transferee of the business referred to in subsection 1 carries on such business either in his own name or some other name, he shall be liable to pay the tax on supply of goods or services or both affected by him with effect from the date of such transfer. So after the business is transferred, he carries on the business in his own name or other name, he will be liable to pay the tax on the supply of goods or services with effect from the date of the transfer. Now let us take an example of this for you to understand better. Here, okay, Mr. A, or I'll give you an example of a partnership firm. A and O, okay, is a partnership firm which has sold its business to B and O. Okay. The date of sale is 1st December 2023. Okay, 1st December 2023. Now, with regard to GST liability, before 1st December 2023, with regard to GST liability before 1st December 2023, both A and O and B and O shall be jointly and severally liable. Okay, shall be severally liable. Now, this GST liability can be determined earlier, before 1st December, or liability relating to the period before 1st December can be determined post 1st December. Okay, did you understand? So either GST liability you already know before what it was, or post this 1st December relating to that period it got generated. Okay, in both these two aspects they will be jointly and severally liable. Jointly and severally liable. This is what is covered. The second situation is post 1st December. Post 1st December, the liability, if any, shall arise on B and O, who is the transfer. Who is the transfer? Fine. So this is the example what is there here. So on this particular thing, the liability will arise on the particular transfer. So I hope this point is clear. Okay. So that was your liability to pay the tax in case of transfer of business. Any confusion with regard to liquidation, transferee can file an appeal with the AAR? No. AAR refers to only the cases which are given in 97 subsection 1 and 2. Those points only he can file an appeal with the AAR. With liquidation, it's a different topic. That's a different section. We shall come to that now. The company will appoint a liquidator for settling the liability. So that is a different issue altogether. So AAR will not come in this particular situation. Further, if he is a registered person under this act, he shall apply within the prescribed time for amendment of his certificate of registration. Right? So therefore, if he is a registered person, who the transferee is a registered person, he will apply for the amendment in the certificate of registration. That means in the certificate of registration, the new details of the business will have to be there and the registration has to be amended accordingly. Then even in case of death of the sole proprietor, the transferee shall be liable to pay the tax, interest, penalty due from the transferor in case of transfer of business due to the death of the sole proprietor. So I hope you got that point with regard to transfer of business. Now we go to the next one. Liability of agent and principal is a very, very simple provision where the agent supplies or receives any taxable goods on behalf of the principal. Such agent and principal both shall be jointly and severally liable to pay the tax on such goods. That means when I say jointly and severally liable, if the principal says he cannot pay the tax, agent also shall be served a notice, principal also shall be served a notice. You cannot escape saying that I don't know anything, the principal has to pay. Similarly, principal cannot say anything, I don't know anything, the agent has to pay. Both will be jointly and severally liable to pay the respective tax on such goods under the respective act. Okay, that is the thing with regard to a principal-agent relationship. Now we come to the next one, liability to pay the tax in case of amalgamation or merger of companies. With regard to amalgamation or merger of companies, what is the respective liability to pay the tax? So what do you mean by the term amalgamation or merger? Can anyone tell? Whoever has done your advanced accounting, financial reporting classes can be tell. So what do you mean by the term amalgamation or what do you mean by the term merger? Two or more companies coming together. So basically two companies which are existent, they are amalgamated to make a totally new company. A company is there, B company is there. They are merging with each other to form a new company, C company. Fine. So therefore, that is your amalgamation point. So when two or more companies are amalgamated or merged in pursuance of an order of court or of a tribunal or otherwise, and the order is to take effect from a date earlier to the date of the order. Okay, so two companies are amalgamated or merged with respect to the order of the court or tribunal, and the order is to take effect from a date earlier to the date of the order, and two of such companies have supplied or received any goods or services or both to or from each other during the period commencing on the date where the from which the order takes effect till the date of order. Then such transactions of supply and receipt shall be included in the turnover of supply or receipt of the respective companies. They shall be liable to pay the tax accordingly. Now, what does this mean? Now, whenever there is an amalgamation of two companies, the respective application will be filed with the registrar of companies and then the respective order shall be given by the court or the tribunal with respect to this particular amalgamation or merger. So sometimes whenever the actual date of the order is there, because now let me give you an example. Two companies want to get amalgamated. They filed for the respective scheme of amalgamation with the respective ROC and the respective company law tribunal on say 1st December 2023. 1st December 2023 you file it. Then after looking at all the documents and all, the tribunal passes the order say on 20th December 2023 approving the amalgamation. Right? So therefore here what is happening? The date of the order is 20th December, but the amalgamation scheme is 1st December 2023. So the order is to take effect from 1st December, but the actual date of the order is 20th September. So what does this mean? This means between this 1st December and 20th December, if these two companies have supplied or received any goods or services from each other, then you will have to include it in the respective turnover of the supply of that company A and the receipt of that company B, and they shall be liable to pay tax accordingly. I hope you understood the point. And for these purposes of the Act, the said two or more companies shall be treated as distinct companies. So they'll be treated as a separate companies up to the date of the respective order. They shall be treated as a separate company. Distinct company. Again, the registration certificates of the said companies will be cancelled. The merged company new certificate will be taken into consideration for this particular purpose. Fine. So that was your point with regard to liability to pay the tax in case of amalgamation or merger of companies. Now we come to someone said liquidation. So section 88 deals with liability in case of the company in liquidation. So with regard to the company in liquidation, what does this mean? So whenever the initiation by liquidator is there, so where the company is being wound up, that is, the company is being closed down or under the orders of the court or tribunal, etc., the person who is appointed as the receiver of any assets of the company, okay, whoever is appointed as receiver of the assets of the company shall within 30 days after his appointment shall give intimation of appointment to the commission. So therefore, what do you mean by liquidation of companies? How does the brief process happen? Can anyone tell me? What do you mean by liquidation of companies? What is the brief process for liquidation of companies? Can anyone tell me? Just in 2 or 3 lines. So therefore, a liquidator as such is appointed whenever the company is insolvent and the company is to be wound up, or voluntary winding up also is there. So what does a liquidator do? The liquidator identifies who are the creditors of the company, from the secured creditors to the unsecured creditors, and also when it comes to the tax payments, the liquidator identifies all those particular payments and makes the respective payments to all the parties which are the creditors of the company. So whenever a person is appointed as a liquidator of the company, first that person will give intimation of his appointment to the commissioner. So therefore, in this particular situation, where any company is being wound up, either by the orders of the court or the tribunal, every other person appointed as a receiver of the assets of the company liquidator shall within 30 days after his appointment, okay, within 30 days after his appointment will give intimation of his appointment to the commissioner. 30 days after appointment, we'll give the intimation of appointment to the commissioner. So again, what will happen here? The estimation of tax interest penalty, which is payable or likely to be payable by the company by the commissioner. So the commissioner shall, after making such inquiry or calling for such information as he may deem fit, he will notify the liquidator within 3 months from the date on which he receives intimation of the appointment of the liquidator, the amount which, in the opinion of the commissioner, would be sufficient to provide for the tax interest penalty, which is then or likely thereafter become payable by the company. So what happens? Very simple, step-by-step process. Liquidator will get appointed within 30 days from his appointment. Within 30 days from his appointment, he shall give intimation of his appointment to the commissioner. He will give intimation of his appointment to the commissioner. Once he gives the intimation of appointment to the commissioner, what he will do? He will make some inquiry. After he makes the inquiry, he will call for some information, and within 3 months, he will notify the liquidator with regard to the amount which is required to be, which he feels, the commissioner feels that this is the amount which this particular company which is getting liquidator may have to pay. That is the process which has to happen. Also, another important point with regard to directors of the company. With regard to the directors of the company, they will also be jointly and severally liable for the payment of tax, interest, and penalty not recovered. So, where a private company is wound up, and if any tax, interest, or penalty which is determined, which is there, you cannot recover from the respective company. That every person who was the director of the company at such point, during the period for which the tax was due, shall be jointly and severally liable. So, very simple. First, they will try to recover from the private company the respective tax, interest, and penalty. In case the tax, interest, and penalty from the private company cannot be recovered, so what it will do is, it will, if the tax, interest, and penalty cannot be recovered, in that particular situation, every person who was a director of the company during for that period shall be jointly and severally liable for the payment of such tax, interest, or penalty. However, director shall not be liable if he proves to the satisfaction of the commissioner that such non-recovery cannot be attributed to gross neglect, misfeasance, or breach of duty on his part in relation to the affairs of the company. So therefore, if he proves that there is no breach of duty on my part, there is no neglect on my part, I don't think there is any, I am able to prove that there is nothing which I have done wrong. In that particular situation, the director shall not be liable to tax. I hope this point is clear, and when the director will be liable and when it shall be liable to pay the respective tax. Okay, I hope this point is clear. Realizing the assets, discharging the liabilities. Correct. Fine. So that was with regard to liability of the director. In case company you cannot refer, you will recover it from the directors. Liability of the partners of the firm to pay the tax. Again, just like private company, if any partnership firm is there, that respective partners shall be liable to pay the respective tax payment. Okay, so notwithstanding any contract to the contrary and any other law for the time being in force, where any firm is liable to pay the tax, interest, or penalty, the firm and each of these partners of the firm shall be jointly and severally be liable to such payment. So, where the firm is liable to pay the tax, and the firm and each of the partners shall jointly and severally be liable to pay the tax, and when it comes to retiring partner, up to the date of retirement, he shall be liable to pay the tax. So, where any partner retires from the respective firm, he or the firm shall intimate the date of retirement to the commissioner by the notice. Again, this intimation is important, and he shall be liable to pay the interest and penalty up to the date of retirement, whether determined or not on that. However, no intimation is given within 1 month from the date of retirement. the liability of the partner shall continue until the date on which intimation is received by the commissioner. Therefore, just because you are retiring from the partnership firm, it is not like you will not be affected. It is your responsibility to give an intimation to the commissioner that you are going to retire, and you will not be able to, you will be able to pay the tax only up to the date of retirement. So within 1 month, if you don't give any such intimation, that liability will continue till the date on which such intimation is received by the respective commissioner. Section 91 talks about the liability of guardians and trustees. Now, whenever there is a guardian, okay, of a minor, etc., in that particular situation also liability is applicable. So where the business in respect of which tax interest penalty is carried on by the guardian, trustee, agent, or any other incapacitated person, okay, the tax and penalty, interest and penalty shall be recovered from such guardian, trustee, or agent. So minor is there. Like example is, there is a minor under 16 cricketer or under 15 who is making some money, and in this particular situation, the respective guardian will be expected to pay the tax, trustee, or agent. This tax interest penalty shall be levied and recovered in like manner, to same extent determined from such minor as if he were a major person, as if he was conducting the business himself. All the provisions should therefore apply accordingly. Section 91 therefore refers to the liability of guardians, trustees, etc. Now we come to liability of the court of wards, etc. When I say court of wards, in case of any estate or any person who is owning a business for which tax interest is payable, is under the control of court of wards. When I say court of wards, if any taxable person is there, he is expired, he is no longer there, the court will appoint as a particular court of wards administrative general or official trustee for the purpose of recovering the respective tax payable. In this case, the tax interest penalty shall be levied and recovered in the like manner as it would be determined from the taxable person. Now we come to the special provisions regarding the liability to pay the tax interest penalty in certain cases. So first one, on death of the person. So whenever a person dies, what happens to his liability of tax interest and penalty? So where a person liable to pay the tax interest penalty dies, and the business is continued after his death. Business is continued after his death. So if the business is carried on by the death by the legal representative or any other person, such legal representative shall be liable to pay the tax interest or penalty if the business is continued after the death. Now what happens if after the death of the person, the business is discontinued? If the business is discontinued, what will happen? The legal representative will have the estate of the deceased, whatever wealth he has left out. In this respect of the estate, to the extent of which this estate or wealth will be able to meet the respective tax interest or penalty, and whether such tax interest penalty either before his death you have unpaid and determined, or is determined after his death, the successor will be liable to pay the tax interest and penalty due from such transfer in case of transfer of business due to sole proprietor. So therefore, in death of the person, if you look at a small example here, so person dies on say 1st November 2023. Okay. Situation 1, business continued by the legal representative or any other person, his son or any other person who's going on the business. Tax liability shall be on the legal rep or other person. Situation 2, business is discontinued, then legal representative shall meet the tax liability from the estate of the deceased. Okay, tax liability can be determined before the death and being unpaid, or can also be determined after death. Okay, I hope you got the point. So this is with regard to the case when a person dies, what happens to the liability to pay the tax, interest and penalty. Now we come to the partition of HUF for any other person. HUF, Hindu undivided family, is basically an age-old concept which talks about what is the concept of a Hindu family. A Karta is there who takes care of the assets and liabilities of the HUF, and whoever is born in the family automatically becomes a member of the HUF. Now, if the HUF has all the properties in its name, the partition of the HUF will come when the boy child of the particular HUF gets married. He gets a separate HUF for himself because he himself becomes the Karta. Then the assets of the HUF will become partitioned to all the respective members who consequently become Kartas of other HUFs. So therefore, in this particular situation, an association of persons is basically many persons, more than one person who club together and form an association for a common purpose. So a taxable person liable to pay the tax, interest, penalty, or a HUF or an association of persons, and the property of the HUF or AOP is partitioned among the various members or groups, then each member or group of members shall be jointly and severally liable to pay the tax, interest and penalty up to the time of partition, whether such tax, interest, penalty has been determined before and unpaid or determined after the partition. So each member or group of members will be jointly and severally liable with regard to the tax which is unpaid before up to the time of partition, and also which is determined before but has remained unpaid or determined after the partition. Then dissolution of firm. What happens when the firm is dissolved? That is, the firm is no longer in existence. So where the person who is liable to pay the tax, interest or penalty is a firm, and such firm is dissolved, then every person who was a partner shall jointly and severally be liable to pay the tax, interest and penalty due from such firm under the Act up to the time of dissolution. Okay, up to the time of dissolution, whoever is the partner of that firm shall be jointly and severally liable to pay the tax, interest and penalty up to the time of dissolution. Up to the time of dissolution. Fine. Any queries here till now? Now we come to the termination of guardianship or trust, where any person is a guardian of a ward, that is of a minor. The minor has a business on whose behalf the business is being carried on by the guardian. Also, a trust is being created. Why is that? Usually the family trusts are being created so that the business is run till that particular person becomes a major. Okay. Now, what happens if that guardianship or trust is terminated, is no longer the guardian, or there is no longer the trustee? Then the ward or beneficiary, whoever is there, ward is the nothing but the minor, or the beneficiary shall be liable to pay the tax, interest up to the time of termination of the guardianship or the trust. Fine. These are other cases which are there. Now we come to section 94, which talks about discontinuance of business by the firm, AOP or HUF. So when you are looking at a firm, when you are looking at an association of persons or HUF, it has a business and it has discontinued the business. Then all the tax, interest and penalty payable under the Act may be determined as if no discontinuance has taken place, and every person who was a partner of the firm or a member of the AOP or the HUF shall be jointly and severally liable to pay the tax. Okay. In this particular situation, the tax, interest and penalty up to the date. So here the most important point is up to the date of discontinuance will be determined as if no such discontinuance taken place. Every person who at the time of discontinuance was a partner or a member of the family shall be jointly and severally liable to pay the tax. Change in constitution of the firm or the AOP, where the change has occurred in the constitution of the firm or the AOP, the partners of the firm or the members as it existed before or as it is after shall without prejudice to the provisions jointly and severally be liable to pay the tax, interest and penalty due from such firm or association for any period before its reconstitution. What do you mean by reconstitution of the firm? That means where new partners get admitted or old partners get retired. There is a change in constitution. So whenever that happens, when the partners or the members of the association, before the reconstitution, there are few partners. After the reconstitution, there are few partners. They shall be jointly and severally liable to pay the tax, interest, penalty due from such firm association for any period before its reconstitution. They shall be liable to pay the respective tax. Also, the provisions of 94(1) shall, so far as may be applied, where the taxable person is dissolved or where the taxable person has effected the partition, with respect to the business carried on, accordingly, reference to the subsection discontinuance shall be construed as a reference to dissolution or to partition. So, wherever the dissolution is happening, it is very similar to discontinuance of business. But therefore, wherever I say discontinuance, it shall be construed as a reference to dissolution or partition. Also, limited liability explanation has been added. Limited liability partnership also shall be considered as a firm. Court here means the district court, high court, or the Supreme Court. Now, let us look at a few questions. Avatar Industries, a registered person under GST, has sold whole of its business to Rolex manufacturers. Determine the person liable to pay the GST, interest or penalty under GST law, determined before sale but still unpaid, due from Avatar Industries up to the time of such transfer. Please try to answer this question. Both these questions, in fact, you can try to answer. So here, where the transfer of whole business has occurred, in this particular situation, the person liable to pay the GST, the transferor as well as the transferee shall be jointly and severally liable to the GST with regard to the GST. And the second question, please try to answer. Second question refers to the principal and agent relationship. Therefore, even in case of a principal and agent relationship, when the person liable to pay the tax, both the principal and the agent shall be jointly and severally liable. So with this, we come to the end of the second chapter also, that is the liability to pay the tax in certain cases. Now, since we have some more time, let us start the chapter relating to job work for some time. At least we'll just go through the introduction and the respective definitions. And after that, we can continue it on the next. Also, an important announcement that tomorrow you will not have any class. The class has been rescheduled to 26th, that is on Tuesday 26th 6 p.m. will be our last session with regarding to the GST, where we'll look at the chapter of miscellaneous provisions as well as part of the job work chapter, which is supposed to be completed. So therefore, what do you mean by the term job work? Can anyone tell me? What do you mean by the term job work? You must have read this job work word when it comes to input tax credit. We shall look at those provisions also. So what do you mean by the term job work? Why do you think it is very significant in the GST law? Outsourcing, okay. Anyone else? Outsourcing is to some extent correct. Further processing of what? Further processing, you say, but of what? Supply of service, schedule 2 of section 7. Okay, that is fine. Again, so basically, if any goods are there which are being sent to any other particular person to do a particular process on the same, it is referred to as job work. Okay, so therefore, the goods which are sent to a particular person for doing a particular process on that, it is known as job work. Now, this process, once it is completed on the goods can either be given back to the main person who sends it. The main person who sends the goods for the job worker is the principal. The person who does the job work or the process on the goods is known as the job worker. So this job worker can either send back the goods to the principal after job work is completed, or after completing the job work, he can further supply the goods to the final customer. These two situations are there in the job work concept. So therefore, job work sector therefore is a significant industry. Not everyone have the bandwidth for manufacturing everything. They want to give many particular small things like say, if you give me an example, diapers for babies. Himalaya is a brand. Himalaya brand makes the diaper, but the small activities of attaching the threads and putting the main component of the diaper is outsourced to any other particular entity. They complete the work and send it back to job work. So therefore, this outsourced activities, they may not be manufactured as such. It is the processing of the goods, inputs, semi-finished goods supplied by the principal for further processing. Therefore, any treatment or process which is applied on other person's goods is a supply of service. Principal again is a registered person who sends the inputs or capital goods to job worker for the purpose of carrying out the job work. So many facilities, concessions, etc. are being given. So main idea here is the principal needs to be responsible for making the compliances on behalf of the job worker on the goods processed by him. considering the fact that job workers are small persons or processing units who are unable to comply with the discrete provisions of the law. GST law makes special provisions with regard to removal of job work. So you can either remove the goods for job work and receive it back, or you can remove it from the job worker's premises for supply to the ultimate customer. The benefit will be available both to the principal and the job. So what does the definition mean? Treatment or process undertaken by a person on goods belonging to another registered person. This is the most important point you have to keep it in mind. The goods which are sent for the purpose of job work should be owned by a registered person. This person only can send the goods for the purpose of job work, and the person who does the job is known as the job. Job worker, what is supposed to do? Whatever goods are sent by the principal, he has to work on that, and he has to either send it back to the principal or give it to the final customer. So therefore, these are the provisions with regard to that. Job worker, in addition to the goods received from the principal, can use his also own goods. So he can, apart from the principal's goods, he can also use his own goods for the purpose of doing the job, like small accessories, etc. He can use his own goods. So where it is located in principal different states, requirement of registration comes, compulsory registration has to be required. So if the principal and the job worker are in different states, then both have to be registered under GST. Exemption for registration, this is clear for us. Therefore, if the job worker is supplier of services, he is registered under GST, he will be liable to pay the GST and issue the invoices. The value of the services will be determined as per section 15, which is the value of the service. Again, this is nothing but the service charges. Also, if the job worker is using any of his goods for providing the services, that also should be form part of the value of the sum. Also, small accessories like mounts, dies, jigs, fixtures or tools will be used. That also will be taken into consideration. Then, therefore, in this case, value of the mounts, dies, etc. has to be factored in the price, and the provisions relating to job work, as we told, is section 19 and 143, and state laws also prescribe the identical provisions for job work. Also, IGST section 20 also is there. All these definitions we have covered in the past, so therefore it is like a revision for you. Taxable supply means the supply of goods or services or both, which is leviable to tax under the Act. Place of business, what does is defined? Place of business, place from where the business is ordinarily carried on, includes warehouse, godown or any other place where the taxable person stored his goods, supplies or received the goods or services, or place where taxable person maintains his books of accounts, or where taxable person is engaged in the business through an agent by whatever name called. Capital goods, this definition was very critical in the excise laws. It used to be a huge definition. Now it has become a very simple definition. Value of the goods which is capitalized in the books of accounts for claiming the ITC and are used or intended to be used in the course or furtherance of the business. Input means also any goods other than capital goods which are used or intended to be used by the supplier in the course or furtherance of the business. Registered person also we have seen, who is registered under section 25 but does not include a person having a unique identity number. Fine. So that was the respective definitions in the job work. Now this is a slightly big topic, so I don't want to start it now and again have a break, and plus also there may be many students who are attending only that particular chapter. So what I will do is this class we shall conclude now itself. We have some time, in fact quite some time, around 20-25 minutes. If anyone has some queries with regard to what we have discussed for advanced students, you can please feel free to post. Otherwise, we have these two topics. One is your job work provisions and one is your miscellaneous provisions. With regard to miscellaneous provisions, you have a lot of topics which we have discussed. The topics pertaining to, I'll just tell you what are the topics which we'll be going to discuss. Multiple small sections are there which speaks about presumption of documents, power to call for information, consent for sharing the information, submit laying of rules, regulations, Small provisions are there, which is basically the last topic in your examination. Multiple small sections are there, which we shall cover in our last session on the 26th. Apart from that miscellaneous provisions, we shall also cover the job work provisions. So also anti-profiteering is a very important provision which is there in the miscellaneous provisions chapter, that is section 170. That is an important point which you have to remember. So therefore, just to revise on what all we have covered in today's session, we have basically covered 2 chapters and we have started 1 chapter. So basically 2 small chapters. The time allotted was there for 2 chapters, but those 2 chapters were reasonably very small. In fact, National Appellate Authority was a new provision which was added, due to which the advanced rulings became a slightly bigger chapter. Also, otherwise that is as small as it was smaller than what it is now. So therefore, what all have we discussed today? We looked at the concept of advance ruling, which mentioned that any clarification with regard to any particular provision is any particular provision. If you have any queries, you can apply to the authority for advance ruling. And certain specific items were given with regard to that. It's questions regarding time and value of supply, classification of goods and services. With these topics, if there's any doubt, you can apply to the authority for advance ruling, and the authority of advance ruling will pass an order which shall be binding only on that particular applicant. It shall not be applicable to any other person in the state or to any other person outside the state also. It shall not be applicable. And then once the authority of advance ruling passes the order, the applicant as well as the proper officer can file an appeal against that particular decision to the AAAR, which is the Appellate Authority for Advance Ruling. And once the Appellate Authority for Advance Ruling passes the order, that will again be final and binding. Please note that if the AAAR there is a difference in opinion with the members of the AAAR, then it shall be deemed as if no advance ruling can be given with respect to that particular issue. Apart from this, there is a further concept of National Appellate Authority for Advance Ruling. When will this come into existence? Where on a similar issue in 2 different states, there are conflicting advance rulings which are mentioned. Then whenever the last conflicted ruling is there, you can appeal before the National Appellate Authority for the purpose of clarification. It will give a ruling which will be final and binding on the respective applicant and the proper officer with respect to the applicant, and also to the distinct persons of that particular applicant who has establishments in multiple other places. Again, the composition of this National Appellate Tribunal is important. It shall contribute of extremely qualified persons, and the rules are given which we have discussed at length, and whatever the appeals can be filed, it is only those same issues which are there. So that was your advanced ruling chapter, and we also worked out a problem. Similar problem may be expected in your examination. And the next chapter was liability to pay the tax in certain cases. We saw the case with regard to mergers, with regard to amalgamations, with regard to transfer of business, with regard to dissolution of firm, with regard to discontinuance of business, partition of HUF, partition of association of persons. Who shall be the person who is jointly and severally liable to pay the tax, up to which particular date? All those intricate aspects we had covered in that particular chapter. Fine. So I hope all of you, in case of distinct persons where advance ruling, whether I think you had asked this question before also, advance ruling can be adopted with respect to distinct person only on the matters which are decided by the National Appellate Authority. So if the regular AAR or AAAR is there, you cannot take that particular ruling. You have to apply separately in that particular state. The simple logic is the AAR and the AAAR is basically a statewide authority. They sit in each particular state. Distinct person, if it is there in that particular state, if the GST registration number again is separate, again it will not be applicable to that person. So therefore, it will be applicable only to the applicant who have applied that ruling. If any other person wants an advance ruling, he will have to apply separately. So then we came to the provisions of job work. We saw certain definitions. We shall look at the concept of job work. when the input tax credit will be available for job work, what is the time limit within which the inputs, capital goods, etc. has to return to the principal or further supplied to the customer. All these points, intricate points, we will see in the next session. And also we shall cover the final topic with regard to miscellaneous provisions under the GST. So with this we come to the end of this session. As I told all of you, our next session will be on 26th of December, where we will complete both the miscellaneous provisions topic as well as the job work provisions topic, which will lead to the end of the coverage of your syllabus. And also I will upload the multiple choice questions for all the sessions what I have taken in the respective link. I would request all of you to try answering those questions and also email those answers. I will give my email ID in the next session. Please make a note of it. Please stay in touch. I'm just an email away. You can, if you have any doubts in any of the topics which we have covered, please feel free to email to me. I will definitely respond to you with the respective query. So thank you very much for your attendance and see you on the 26th at 6 p.m. where we shall continue our discussion for our final session. Thank you very much. Good night, everyone.